I'm Anju Preet, and I will be MC for the event and try to coordinate things and maintain the flow. So we are all very fortunate to have you, Dr. Raja Bhandari ji, for the Will and Trust and Estate Planning session. This is like in very perfect time, and it would be very helpful to our audience. So I would request now Dr. Harswarup Singh ji, Ambassador Harswarup Singh ji, to welcome you formally and present you before our audience here.
Thank you so much.
Dr. Harswarup Singh ji, are you there?
It's my pleasure to welcome Raja Bhandari ji, a well-known personality. He has done a lot in his own field and for the community. I welcome him. A lot has been said about him. That is all true. And I felt like saying, ये ज़मीं चूम लूं, ये ज़मीं चूम लूं या आंखें बिछा दूं, मेरी गली में हुजूर आप आए, बड़ी मेहरबानी, बड़ा शुक्रिया, मेरी गली में हुजूर आप आए, आंखें बिछा दूं, पलकें बिछा दूं या आंखें उड़ा दूं, ये मेरी समझ में ना आए. मेरी समझ में गड़बड़ हो गई, but I may be overdoing it. The point is that I'm here to welcome a very accomplished man. We all know him. I have met him a few times in individual setting and of course in a collective group sessions. And I'm very impressed. He is somebody who is highly knowledgeable, very friendly, a wonderful MC, and a great speaker, as you will all see. I also wish to welcome our cooperating groups. There are many, and without their help, we could not have done all that we are doing. We thank them. There would be somebody to thank you all. I would only say that I welcome you to this great event. We all need this kind of advice, and I congratulate our leadership, Mr. Sunil Singh and others, the present president, Nana Desai, the past president, Kirpa Singh, and all the rest, and Gopi Durgaya Naidu.
We won't see you, but we can hear you. So we'll be
All,
right.
they all have done a lot to do good for the community. I wish all of you well, and I look forward to listening the words of advice of Mr. Raja Bhandari, and I'm sure we will benefit. Again, welcome you all. You will be duly thanked by somebody at the end of the program.
Thank you so much, Singh Saab. Thank you so much. So kind.
Thank you very much, Dr. Harswarup Singh ji, for welcoming in on behalf of everybody as part of this NCAIA. So, जैसे डॉक्टर साहब कह रहे थे कि गड़बड़ हो गई, तो हम सबसे कभी कोई गड़बड़ ना हो इस important विषय में, state planning, will and trust में. So that's why we have our expert Raja Bhandari ji here, and his apt introduction will be now given by the event coordinator, Mr. Mukund Agashe. To you, Agashe ji.
Thank you. Thank you. Good afternoon, friends. Thank you, Anjuji. NCI has organized today's program pure as a social responsibility. We are very busy with our careers, family, friends, and other things. But many of us don't take time to do the will or do the estate planning. If you don't have a proper estate plan in place, things can be very difficult and complicated for our children, spouse, and grandchildren. Unfortunately, especially in our culture, we don't like to think about death. But the truth is, death is not if it happens, but when it happens. Death is certain for every person. So why not take some time and take care of this important legal document that one time be done with and do it one time and be done with it. It may be overwhelming when you hear about it, but that is where our expert like Raja Bhandari ji come into picture to make it easy for us. I know Bhandari ji for over 30 years, I think, as I said a little before, probably on a program called Doordarshan. And if Bhandari was not a lawyer, he would have been truly a professor of Hindi literature. He's so wonderful in that one. He has so much command and knowledge of the Hindi literature. But of course, today he's our expert on law. He has been providing law services, legal services, I should say, to the community since 1990, with special emphasis on wills, trust, estate planning, business transaction, personal injury, immigration, and many, many more. They provide the detailed information to the every client. Raja Bhandari's law offices is the foundation on which every successful client attorney relationship is built. Without further ado, please give a round of applause to welcome Raja Bhandari ji.
Thank you, each and everybody, the one who's watching me and listening to me, and the whole members of the board, and of course, the whole organization. This is an opportunity for me to express my gratitude, as well as my thank you, as well as whatever little bit knowledge I gained through the years of my practice that I owe to my community, which I'm trying to do it as much as I can. This particular area of my practice, as Ghazi Saab just mentioned, that of course my office do several things in practice. This particular practice of mine, it was very close to my heart. And the reason it was close to my heart, because our community is way behind. They might have a knowledge, but they don't want to exercise it. They don't want to take advantage of the situation in this particular country, that if you have a tool available, then you can use that tool, save a lot of money, hassle, painful process, and protect yourself as well as your children. So that is what I started 25 years back when I start lecturing on this particular area. And as Agassi sir just mentioned, that people used to shut me off. They said that why maut ke baare mein baat kyun karo? So I remember one share from a very well-known poet. He says, "Maut ki intezar mein jeeta raha hu main." This is the reality of our life. We wait for the day, but we don't want to mention for that day. We are we are here for a certain amount of time with the grace of God, and then we do thank you to God each and every day for our what you call well-being, for our success, for our children. But at the same time, we have to be a little uh, more into this particular thing. We go to work every single day, most of us, and we try to save money. We try to protect our old age situation. We protect that our children should go to good schools. But at the same time, we always forget how to protect ourselves, how to protect our children, how to protect our assets, the one we made. Now, I will just simply say one thing, let's say that you have a bank account and you do not use that bank account for a while. What they do, they send it to state and send you a small card, say that, look, your money is in dormant now. You want to claim it, send us the information. If you do not provide the information in time, state will take it away. Same thing can happen to your property. Same thing can happen to your all other assets. Of course, because if you do not disclose to your near dears, how do they know that you own the property? If you own the property and you are no more, how do they know that you own the property? How do they know that you own the assets? So it is a very critical. It is a very important. I would say just one word. It is a must. And if we do not take care of that during the time that's supposed to be done, we can pay hefty price, and our loved one can pay hefty price. I mean, why do we, if I take care of my children today and I don't see them suffer, why should they suffer when I'm no more? Simple is that. You want to protect yourself first, then you want to protect your children. So we will go from here, one topic to the other. In layman's language, you can call this will and trust. But in our official way of saying is estate planning. Estate planning has several documents. It protects you, of course, your assets and your loved one. And then we will talk one after another, all the documents, and then we will have a question answer series. So Agassi Saab, you can start from the one.
Yeah. Okay. Do you want me to start with or you want to just give us
I can continue
with a high level, whether it's a medical directive and a trust or something? And
sure, I will start with a simple will. Now, when we talk about a simple will is what? It is your directions to the court that, look, if I'm no more, whatever I own, I want to distribute this way. And I want to appoint the personal representative. And I appoint, and then at the same time, these are my directions, should be followed when I'm no more. That's it. It is a legal document. And of course, it is a very important document. And will people take it so lightly? They think that, okay, if I have a will, I'm done. I'm finished. I achieved whatever I wanted to do that. But I want to let you know, will is a good thing to do. It depends upon your estate size, how much you own, how much property you gathered over the years. If you have a large estate, will is not the answer to probate. Because now so many people don't understand. If we have a very bad notion from back home, whatever I own belongs to my children, my loved one. That's it. I don't want to listen anymore. But that is not true. You have to follow the procedure of this country, that you have to follow, because if you own certain things, I understand, but how your children going to get it? There is a procedure. And that is what we call probate. And probate is absolutely lengthy, painful, and very bad experience for the people who go through that. Because each county, each state, wherever you reside, has a different way of doing the system. So for example, I will touch base that let's say that if you have a will and you are no more, your loved one will go to the court and they will open the estate. And then, of course, it depends upon the county, how busy they are. It can take from 1 to 3 years to get your own property. And then it is, of course, expensive. And that is where people make us rich. Believe me, that is the inside story. Because probate is the one where we make money, not making the trust or estate planning, because those are very standard way of doing the documents for us. But to make sure that now when you go to court, as I said, that court will put it in the newspaper that this person is no more. Any creditors come forward, then creditor will start filing the claim. And when they will file the claim, then they will ask your loved one, bring all the assets, all your accounts, all your properties. That will be a public record. Anybody can see it. Anybody can challenge it. And most of the time, believe me, family comes first and challenge. They think that now we see the money. We didn't know that he or she owns that much. Now let's take advantage of that. This is the family drama we see unfold every single day. So now you have a will. You think that, oh, now automatically my children gonna get it. No, you have to follow this procedure. Court will decide if you own $100, you owe $50. So $50 left, you pay all the taxes, whatever is due, and then they will give $50 to your children. Now, how long it's going to take? It depends upon each state and county. This is the situation when you have a will. If you don't have a will, same procedure. Only thing, court will decide who to get what, who will be the administrator, because that way, because you did not appoint anybody. So that is the only difference. You have a will or not will, you're going to end up in a court for probate. So that is the probate procedure in a nutshell. Now let's talk about how you can save yourself a lot of money, hassles, and protect yourself and your children. There are two ways to do it. One simple way to do it, cut your hand, give it everything your children while you are alive. So they can do whatever they want and you can be on the street at one day. Believe me, it happens because you have to take care of yourself first. Remember when you go to plane, what they do? Put your mask. If something happens, make sure when the mask comes, put your mask first, then help others. Remember, this is the same principle in our life. You protect yourself first, then take care of your children. That is the life is all about. So that is one way of doing and very cheap way of doing. So that way you don't have to spend money because that is most of the time people trying to save money and transfer that properties to their children while they're alive. Now, the second way of doing, you can give it everything on plate to your children so they can have your assets when you are no more. Until you're alive, you did not give it to anyone. You can change anytime. You have 100% control. When you are no more, that will go to your children the way you want it to do. And that is what we call trust agreement. So when we prepare a trust is basically what? A company. Or I would say, make it more simple, it is a box. We created a box. We gave name to the box. We put all our assets in the box, which is we call funding. So when we create the box, we put it in the box and we put a condition that until I am alive, I'm not giving anybody anything. I can change anything anytime. When I am no more, I'm going to distribute all my assets to my children equally, whatever the denomination you want, whatever the way you want. You can put condition on ages. Like for example, if husband and wife, they have two children, their age is 18 years, and then they want to make sure that their children should get money when they are 25 or 30. They can put a condition. If we die and they are 18, we will make sure that they should get money only at 25. But at the same time, they should get all the necessities of their life during that period. Now, when we create a trust, obviously, then we also create a successor trustee. You can be the trustee of your trust during your lifetime. That is one. Or you can appoint anybody, third person. That is two. Or you can appoint a company. That is also true. Then you create a successor trustee. Let's say that I am trustee of my own trust. If something happened to me, who's going to take care of my assets? Who's going to take care of my children? I appointed a successor trustee, which we call also a guardian for your minor children. So if you have minor children, if something happened to you, you know, foster home can take it away your children if you don't appoint a proper guardian for your children. because father and mother are the only legal guardian of their children. So you make sure that you protect your minor children. This is a very important issue in our communities. There are so many fatalities happen in the last year in Virginia side, I can tell you. And we were overwhelming in that situation. Young people died and their children, suffer. If they, the most of them did not have a proper document in place. Their spouses are suffering now, and their children are suffering now, and their husband and wife both died. Their children are suffering. Minor children are suffering. So this is very important issue for the minor children if you have one, and if you don't, then of course it is important as well for your other children and your other loved one. So basically, this is what in nutshell we call a trust agreement. You can have any way you want. You can give any directions you want. It is completely your document. You and husband and wife can control that during your lifetime. Now, another important document comes in our life that is called living will. Now, living will is what? Basically, it is a will deal with your health. First will we talked about, that was dealing with your finances. That was talking about money. Now we are talking about health. So living will called a health document, which is you will give a direction that I want to be cremated this way. I want to be treated this way. I don't want artificial life. I don't want ventilator. I don't want this. Any directions according to your religion, any directions according to your customs, whatever the way you want to put you can put that expressions in that will, so that will be taken care of. Then another document comes, which is we call medical directive, medical power of attorney. Now this particular document is basically you are giving a power to a third person. Let's say as of today, I don't have a power of attorney. If something happened to me, when I go to hospital will be taking the charge of me. They will get a general power of attorney from your kids or your loved one. They will decide what they want to do with me. And of course, business is business. There is no loved one over there for you that they will taking care of you health-wise. So then you don't, they have to see their portion first. Are they making money? Of course, they have to run the business. This is a business, hospital business. So do you want third party to take care of your health wealth? I don't think so. I don't want third party to make a decision. My son can make decision on my behalf. My daughter can, my wife can. Why should I give power to a third party to make a decision on me? They don't have any interest in me. They don't have any compassion in me. So you have to create a document and give a proper power of attorney to your loved one so they can take care of you properly when you are not in a position to speak or incapacitated. Now, remember one thing. We were talking about guardianship for children, right? Same thing, life is a circle. All my friends, you should understand that we were guardian of our children will be guardian of ourselves. We remember that time is coming, because when we are old, we are not in a position to talk or be incapacitated. Who's going to take care of ourselves? If you don't have a proper document in place, they might end up in a court to get the guardianship of you, because power of attorney dies with the person. Remember that. Power of attorney dies with the person. So until otherwise you are alive, that power of attorney works. Because let's say that husband, wife suffering, they are not finished yet. Who's going to take care of their affairs? If they don't have a power of attorney in place, then obviously children has to get a guardianship for them. Because how are they going to sign the checks? How are they going to admit them in a nursing home? How are they going to take care of their hospital situation, or all other matter for that matter? So you have to understand these small documents, the one we are talking about now, became a very big document and crucial document when we are in a situation, and then there nobody's going to be helping you. Only court is the court is court. It's going to take time. It's going to be very expensive. That you have to decide. There are two ways to live life in this particular world. Do it prudently or chalta hai. And in our system, we have a lot of chalta hai. Chalta is not going to work now. We have to make sure that there are certain documents in place. Protect yourself first. Protect your assets first. Then protect your children thereafter. So make sure that that is in place. So same way, there's a medical power of attorney. In the same way, there's a financial power of attorney. There are two separate documents. Power of attorney, financially durable power of attorney, manage your affairs when it comes to money. Medical directive, medical power of attorney, takes care of your health and other related matters for as far as health is concerned. So this is how, basically, nutshell, these are the documents, more important document in the trust. So there are two ways to do it. One, we prepare the document, which is we call a tool. Second, we fund the trust. Let's say that you own one house, two houses, three houses, four houses. We transfer that house or houses for that matter to your trust name. Because remember, we created a box. If you do not put your assets in the box, your children cannot get out of that box. So let's say that you have 5 items and you put only 4 items in the box. One item is not there. They have to end up in a court and probate for that item. We don't want to go to court. We don't want to pay filthy fees for us. I'm a professional, but this is how I have to say, because otherwise so many people don't understand that. I might be hurting my business. It's okay. God is very kind to me. I mean, God is taking care of me. So it is my responsibility, whatever I know, whatever I learn from my experience, from people's experience, to share with my community. This is a give back time for me, which I am ready to give and which I'm giving it as long as someone can take advantage of it. Okay. So this is nutshell. We talked about our estate planning. Now, there is a other issue that I want to touch, which we deal every day in my office. A lot of people have properties in India. A lot of people have assets in India or other country for that matter. When it comes to India, of course, we have an office in New Delhi that we take care of our clients so that the client doesn't have to suffer. So let's say you have a properties in India, you want to properly dispose of it legally, and then do proper channelize. And then if you want to bring money here, proper with RBI sanctions and all that with approval, we can help you out. Also, if you have a property in India, you have to make a proper will for India separately. So that way there will be no confusion about that particular area of your life. So sometimes people think that if I create a trust, everything is there, so I don't have to. You can rely upon the trust. It can work, it cannot work. But I would recommend strongly, you should have a proper separate will for India, and then mention all your assets, whatever you own over there. So this is, in a way, nutshell, my presentation. I mean, I can go on, but at the same time, time is a limit. Now, I mean, I would love to answer questions from people. I mean, be very brief. And then if you have any question, you can, of course, catch me somewhere. I mean, rajabhandari.com, and my phone number is there on the 703-941-1850. My way of doing is that I do initial consultation. My office is strictly that we do not charge our community. That is how I do.
It is It was an interesting and very informative presentation, Rajabhandari ji.
Thank you.
And we have invited lots and lots of questions that shows how much interest this topic had for our audience
So
and
nice.
how appropriate your presentation has been. So I have a question that we would start taking as they come.
Sure.
So as you said, we need to have a separate will for India and here. So does it matter where the will or trust is created? I understand these are two countries, but when these are two different states or residences, sometimes you have properties in different states, different counties. So does it have to be in the same state as your residence?
No, not
Or
really. Let's say that you live in Virginia, and then we will create a trust, I mean, as per Virginia law. And then what we will do is that wherever you own the property, doesn't make any difference. We will properly transfer those property with the help of others and record those property in the counties where your property, I mean, is situated. So that way that you have to create your estate planning where you reside. Then rest funding can be taken care of. That's not a problem.
okay. John is asking, like, how about moving the rental house to the trust?
Well, there are
Like,
two ways to do it. Most of the rental properties, people put it in the companies and LLC or corporation for that matter. We can transfer the corporation to your or LLC to your trust, or we can, of course, we can transfer the properties for your from your the rental property to your trust. There are certain procedures I cannot discuss over the air, but we can talk when they can talk to us in person.
okay, because it said like if there's a mortgage loan already on the property, you cannot move it to the trust.
Let me make it clear here. When you own the property and you have a loan, mortgage people most of the time don't have any objection to that matter because they know that you're personally liable for that. And when we prepare a deed for that particular property, when it's going to the trust, that deed is a separate deed, it's a separate language, it's not a regular deed when you buy the house. In that deed, we mentioned several things. It's one of the thing is that you will be remain personal liable for your mortgage. So it's not a issue. I mean, over the years, we don't have any issue in that respect.
Okay, thank you. So Ab is asking, like, if my children has already been added as nominees or beneficiaries to my every financial account and property, do we still need a will or a trust to avoid the probate?
Well, now it depends upon it. When you say they are added to your property, I started with that one thing. Remember, if you remember that, don't cut your hands. I mean, I don't hesitate, I don't mince my word when it comes to adding the children because they have their own life. If you add it to save money or whatever the way you're thinking, now remember one thing, I don't know how you created a deed. It is joint tenants or tenants in common. It depends upon, it is a vague question. We have to see the document to answer that question. But at the same time, when you added your children to your financial institutions, remember one thing, court asks you to probate. If you don't want to probate, what is the meaning of probate? If you owe anybody some money, how are you going to pay that? That means you're trying to avoid it, right?
Definitely.
If I owe someone, I'm responsible for someone, and I transfer everything to my children or someone else I love, who's going to pay on my behalf? So it is a legal question, and I should not go further than that.
Definitely. You cannot take away money from people and go and leave your benefits for your
Right.
own children.
So
Yes,
the
there
only
has
way
to
to
be
do
a way.
that is why when I explain the probate procedure, probate section will ask you bring all your assets. Then why they put it in the newspaper and communicate outside of the court that if there is any creditors come forward, because they know that if there is a creditor, you have a credit card, you owe $10,000, it has to come out of your estate. You have to pay that. Again, I'm just giving you example. Whatever happened at that time is a different story. How they deal with that particular distribution of the funds in probate is a different story. So this is how it's supposed to be. Rest, I hope you understand.
Yeah, moving further, Nandini Narvekar is asking, do you need a single trust for a couple, or husband and wife, they need separate ones?
These days we make two trusts, one for wife, one for husband. The reason for that is because that is a very simple way of doing these days, because it also give you a lot of benefits when it comes to the taxes. So two trusts are much better, clean way to do it.
Okay.
Because when one spouse is no more, everything goes to the other.
So if out of the couple, Nana is asking, if out of the couple, one is living but is either blind or mentally disabled, and the will or trust has not been made yet, what can be done at this point?
Repeat the question. One person is living.
Yes, the question appears to me as if from the couple only one is alive and that person is blind or mentally disabled, and will and trust has not been done yet. So what can it be done at this point?
Okay. Remember when I started making, if I don't mention it, and I will mention it now. There is a Hindi movies. When the person is at the deathbed, they call that ke vakil saab ko bulao. Mere ko will likhni hai. This is life, not Hindi movie. You cannot write, you cannot sign a document when you are not in a state of mind. So you make sure when you write something, when you have a will, trust, or anything, if you don't know what you're doing, that particular document is invalid. So that is why my humble request to each and every one of you, when you are now good state of mind, you understand everything, make the document, make it happen. Otherwise, this situation can arise, the one we are discussing now. It's a very good question. And I thank you to the person who asked that question. So that way I can relate to others that nobody knows what after 1 second gonna happen.
Definitely. One has to be mentally competent.
We have incidents. This particular practice of mine is a very emotional practice. We get calls from hospitals. We get call from when the person is sick, when the person is no more. It's just like a doctor's. So when you mentioned Dr. Raja Bhandari, thank you so much. This is how we work also sometimes.
Yes.
So it is of course, we are a doctor. We are jurisprudence doctor. That's what they call JD.
Definitely.
So we are also counselor. But at the same time, that's besides the point. That's it, pun intended. But please try to understand that this is a life. If you don't have a proper document and you make a document while you are intoxicated through the medicine, your brain is not working. You have no idea. You're under medication for that matter. That document can be challenged very easily, and that will be invalid document.
Yeah, definitely. When one has spent entire life earning and saving money and making property, one should make this important decision while one is competent enough to do that.
Most of the time I've been asked this question, I can share with you. People ask us, what's the right time to make a will? The right time to make a will when you start making money. Even you are 18. Because if you are making money, you have to appoint someone if something happened to you. Death doesn't see how old you are, how you are, where you are. So if you think that, some people think that after 60 or 70, we will think about these documents. No, you're too late, but you're still in the picture. Get it done.
Sasi is asking, can I do it by myself without attorney's help? Like using the online websites to have it made in an inexpensive way?
I don't want to make comments on someone who makes these documents. God bless them. One bill doesn't fit all. if I have a pain, which I don't know where I have or how I have, Tylenol can take care of me for a second or, hour, for 2 hours, 3 hours, or 3 days. I have to end up getting to a proper doctor and get a proper prescription for that matter. These are legal documents. If you come to my office, I'll show you stacks after stacks. The people get it done, spend money, then they find out that this is not good, then they come to us, then we make their document again. Because remember one thing, why we are doing these documents? We are doing it to protect ourselves, our assets, and our children. If you don't do it properly, and you don't execute properly, don't notarize properly, I don't know what document is that, whatever you're doing it. You did not do anything to begin with. It's invalid, can be challenged. So why take chance? I cannot do my own surgery.
Definitely.
Just think about it. If I don't know anything, if I can go online and say that, okay, cut myself like this and take this out and then, make it stitches like that, I don't think so.
Yeah. I have an interesting question from Ronit Malik. So he is asking, is there a difference for trust making for visa holders versus the US citizens? And another one is, should we make a revocable or irrevocable trust?
I'll take a second question first. Most of the time we make revocable now, because when we do the other way, then IRS get involved. Then you cannot sell the property the way you want to sell anytime you want. You won't have 100% control over it. So revocable is the key these days. Second question is that as long as you have a valid visa and as long as you have assets in this country, and you are buying the house or you have a house, of course you can create a trust. Of course you can prepare it, because you are here and you will be treated according to the laws of this country. So you can make the proper documents wherever you are, in which state you are.
Okay. So you told us, like, if you have property in multiple states, we can have a will or trust registered in the state that we live in. Is it mandatory that it to be done in the state of our residence, or we can go to have it registered in some other state as well?
Okay. Number one, when it comes to registration, trust is never get registered anywhere. This is a private document. Okay. When it comes to registration of your will, it is up to you. These days, people don't do that. So you don't have to do registration for that matter.
Okay.
Now, when it comes to creating a trust, because you are a domicile of one particular state, so you have to follow the laws of that particular state when you are in. So you create the document in that state, and then you can fund the properties in that trust. That's not a problem.
I just want to add something, Rajaji. I think just follow-up question on what Anjuji asked. People these days go to Florida after retirement or something. In that case, do you change your the trust you have made, or you can continue to use that without making any changes?
Well, it depends upon your estate, number one, how large it is. Number two, whenever you move to another state, just talk to the attorney of your choice in that particular state. And then they do is that they do the amendment to that trust, that this particular trust will be, now will be dealt or deal with, rather, will be that particular state under that laws. So it should not be any issue, big issue. You can move any state for you want to do, but only thing is that they take advantage of the proper knowledgeable person in that particular state, so they can guide you through.
So, Raja Bhandariji, do you have an office in Mumbai, lawyer or?
No, we don't. We have office in Delhi,
Okay.
not in Mumbai, but we can manage anywhere in India. So that is not, because Indian system is different than here. So our office can manage anywhere in India.
So Girishan is asking, like, whether you would shed some light on the cost associated with different documents like living will or trust.
We don't discuss the cost over the air. We don't.
Okay.
because each person has different needs and different way of doing it.
Yeah.
You're most welcome to give my call myself, call my office. We'll love to discuss with you. But we don't discuss feces on over the air
Okay.
due to ethical reasons.
So
भंडारी सॉरी भंडारी जी एनसीआईए के स्पॉन्सर जो लोग होंगे उसको कुछ डिस्काउंट देंगे आप?
मैं सारा ही दूंगा जी। बिल्कुल बिल्कुल मैं अगर मैं यहाँ बैठ के my whole idea of is this particular practice is to do as much as for my community that I can do.
Okay, good. Good, thank you.
Sure.
So there are so many questions. We can go on and on for this. I will ask you and let us know when to stop and what to do.
I am a non-stoppable person,
Okay.
and it is up to you.
Okay. So John is asking, I live in Texas. Can you still help us create the trust for Texan and move properties into the trust?
No, we cannot. You have to find out the attorney from the tax.
Okay. So only Virginia. Okay.
So
If
does
we-
that mean you can do it only in Virginia, or you can do at least the tri-state?
We have attorney. We do that. Virginia, we have attorneys for Maryland. We do it DC. We do it Pennsylvania.
Okay.
Okay. So one question is like, if we make, Asha ji is asking, like if we have a revocable trust, do our heirs still need the attorney for passing, like after the parents pass?
This is how it works. They can go to attorney, one, they can go to a proper CPA, because what happens is that once you are no more, your trust become irrevocable. You cannot revoke that trust now. What you have to do, you created a paper person. Now we have to say goodbye to that person. How we can say goodbye to that person? We have to talk to the Uncle Sam. So Uncle Sam, this person was there and we have this much money. We owe you some money. If you don't, let's file a tax return. So give us a tax ID number for this person. So this CPA will file a final tax return and distribute your property, or you can distribute your property according to your needs.
Rama is asking, if husband and wife has a will and husband passes away, does the wife still have to go through a probate to change the deed?
She has only will.
Yes.
Okay. Now question.
One of them passed away, like the husband passed away. Does the wife still has to go through probate, change the deed?
Still filming.
There is a situation coming up last few days that I have so many calls on this issue. This is what happened. I explained it to you earlier that will is not the answer to your probate. Will is mere a directions. Is a directions to the estate that after me, give it to my children, my wife, or whatever it is. Now, sometime husband and wife owns joint account. They cannot operate because bank can freeze the account because the person might owe somebody money because they find out that there are creditors coming forward. When this kind of situation happen, unfortunately, you're going to end up in a probate.
So one question from Senthil, like for India, do you need a will or a trust?
Will is sufficient enough.
In India. Okay. Okay.
And we do that every day in our office. There's a different procedure. And there's an embassy is involved in that in a way that when we prepare a proper will and proper witness and proper notarization and execution, when we finish, you have to take that will to the embassy to authenticate it. So they will certify that this is a true document.
Bhandariji, do you have a website or a phone number that I can share with people on the message?
Haji, you as you see that under my name, there's a very simple way of reaching me is that rajabhandari.com because we have a site. So, and then second, of course, I can share my number is 703-941-1850. Again, 703-941-1850. And our email address is legallords@gmail.com.
That's awesome.
Yep.
Yeah. And
I have a question, Rajaji.
Yes.
Well, the question is very simple. Sometimes people put their trust in their own will. They define this is my trust. Every document prepared as a will, but will is also having the trust inside it. After that, is that good document or this document need to be changed? Then I have second question for that about the probate. The probate and the trust. These are two different things.
Now, number one, when it comes to will, Doctor, will is a small part of estate planning. When you have a proper trust, you don't need a will.
Oh,
So trust is the one going to take care of everything as long as you fund the trust. That is why we created the trust, so that way you don't have to go to probate. If, again, I will touch base again, will is a mere directions to the court that I own certain amount of properties and assets, and this particular person I mentioned in the will is my administrator, and I want to distribute my assets to my children, loved one, this way, whatever the way you mentioned in the will. Will has to be properly executed, has to be written under state of mind. There should be proper witnesses according to the state and county, and it has to be properly notarized and properly written. If you don't have a properly written, judge can throw that will out, say it's invalid. So you did not make anyone. If you don't make a will, let's say that today I don't have a will and I am no more, my children will go to court. They will open the estate. Now judge will decide who will be the administrator, how the property is going to be distributed, all that, because you did not give any directions. So will is a direction to the court only. That's it. Probate is not going to be going anywhere. You go, you have to, you understand that some people think that they can get away with that without probate. Good luck.
but inside the bill, one
No.
has nominated, designated who will execute this bill, who has the power to execute this will. This is written in the will itself that yes.
Doctor,
Yes.
no. As of today, you own the property. If you want to sell the property, what are you going to do? Answer me, please.
Yeah, we'll sell the property as if it is my own property. I'm selling it.
Okay, you and your wife sign the deed, right?
That's right.
When you're no more, who's going to sign the deed?
Which part of that I'm not clear.
I said, when you're no more, who's going to sign the deed to sell that property?
Yeah, that is so. When the joint account is always there, so second
No.
partner will do the sign, but that will not be acceptable.
If both of you are not there,
Then the person who has been authorized in the bill, that guy will take over.
right? And that is why we have a procedure that is what called probate. I'm not denying that person doesn't. You're talking about personal representative. Personal representative has the power to sign the deed, but has to go to probate. All the money will come to the probate account when a distribution happens.
So what you are recommending that everyone should have a will and a probate or a trust? I mean, how many documents one has to keep? Will, probate, trust. All the three documents should be ready.
Okay, let me go back again. What exactly I was mentioning that if you don't want to go to court for probate, then you should have a trust.
Okay.
And when you have a trust, then you appoint a successor trustees in the trust. During your lifetime, you own the property, nobody can touch it. After you gave it to your children, they are the successor trustee also, so they can sell the property without going to the court. They can distribute among themselves without going to the court, only thing they have to do when they finish doing the distribution, they have to file the final tax return for your trust to dispose of.
Thank you, Bhandari.
One thing you also mentioned
I
about
think
the
Gupta
bank
ji, we will
account.
come back
That
to
is very
you.
important.
And
Bank
Gupta
account,
ji will come
and
back to you. We have
I
few more
think,
questions.
Bhandari ji, you really made it very clear that in absence of a trust, even if you leave a will, you have to go under probate, which is a process taken by the court to settle your account. If you owe someone, they will give that money to that person, whether that money comes from your insurance, your assets, or wherever the sources are, your entire assets will be looked upon, and whatever needs to be given will be given to the third party, fourth party, or whosoever is putting the claim on the thing. And after that, whatever is left will be distributed as per your will, if
Correct.
that's
Yes.
correct.
Bhandari ji, this is Satish Mishra. I have a simple question. What is the difference between joint point between Mr. and Mrs.? The second option is Mr. or Mrs. So what is the difference? If you have a joint bank account or stock market account, if I put Mr. and Mrs. versus Mr. or Mrs.
Again, that question goes to your bank. Bank
No, in terms of somebody dies, what happens?
Again, I would always recommend you should have an and joint accounts.
Joint means what?
That like Dr. and Mrs. Mishra.
That word and
Yeah, that's Dr. and that is joint account.
Doctor R. You want to? My preference would be R. Doctor or Mrs. versus Doctor and Mrs.
Let's don't discuss on the air that what is your preferences. Otherwise, Mrs. Mishra is going to be very upset.
No, I don't want her to be.
I don't want to go to that route. So, Dr. Mishra, don't talk on that issue. Otherwise, I'll get a call right after at home.
No, one can still operate if Doctor and Mrs. is there. Both have to sign.
Legally, I would recommend it should be joint account with the right of survivorship. That is what I recommend. Rest is up to you.
Okay, thank you. You answered the question.
There is one last question I would ask about the revocable trust. Do we need a pourable will? What?
That is a, when you have a will, only will, that is we call simple will. When it comes, let me explain it to you. There are several kind of wills. One is a simple will, one is a holographic will, one is a pour over will, and one is a living will, which we discussed. Living will is a medical related. Simple will is a proper. Holographic is that when you write your own will with a hand. So there are certain states accept, certain states don't accept. As long as it's properly written and witnessed and then properly executed, sometimes it's accepted, sometimes it's not. It depends upon the case. Now, when it comes to pour over will, that is only in the trust. When we prepare the estate planning, any will in that one related to financial, it will be called pour over will. That's all.
Okay.
Anjuji, I think, Anjuji, 1 minute. I think you may have missed the question. There is a question here from AB. I don't know who the. If I add my children as a nominees, beneficiaries to every financial account and property, do I still
I did not repeat the questions, Bhandariji, which, sorry,
already
Kunji,
answered
which
that.
Bhandariji already explained in his session. So I skipped those questions because that was already covered as part of his presentation.
Onjo.
Is that?
Hello, Radhaji.
Dada.
Yes, Dr. Banik. Welcome.
First of all, I want to congratulate you on behalf of NCAIA for your brilliant presentation. Your name, Raja Bhandari.
Thank you.
Raja Bhandar, you have so much knowledge. You remember, we got revocable trust for both myself and my wife 20 years ago.
20 years ago, yes.
One from his wife called Rani Bhandari for my wife.
Thank you.
And I got for me Raja Bhandari.
Thank you.
The king and queen got both revocable trust from Raja and Rani Bhandari.
Thank you. Thank you so much, Dada.
And I'm still alive.
That's awesome.
I want to tell you,
God
Raja,
bless you.
That's
You
awesome,
are,
Dada. Thank you for sharing that with us.
your
That will
presentation
motivate
was
us to get
phenomenal,
our will
and
and
Dr.
our
Unju Preet
trust made.
did a superb job.
Thank you,
So
Dada.
I
Thank you,
want,
sir.
on behalf of NCIA, I want to tell you how much we enjoyed your presentation this afternoon. And say hello to your Rani.
Thank you.
I
I
was
will.
hoping to see you next week.
Dada, it has not been finished yet. Let us complete the questions.
Okay,
People are waiting for
Nanjuji,
that.
try to now,
Dada,
what's the
I
difference
think
between
Mukund has a question, which
revocable
is valid
and
question. Lot of
non-revocable
interest
trust?
is there. Mukund, can you go with your question, please?
Thank you very much, Dada, for giving us your experience with Raja Bhandari ji. That will motivate us all youngsters to get our trusts made in time, so that we don't have to wait at the last minute. So now, thank you very much, Raja
I
Bhandari
think
ji,
Mukund
for
has a
taking our
question.
questions
Let's
at
have that question, Mukund.
detail. I would like, if Mukundji, you have any other question that you want to ask, otherwise.
Hold on. Hey, Anjuji, hold on. I have sent a question to Bhandari Sahab about the tools, if there is any available. So, Bhandari Sahab, just a quick question that do we have any tool like TurboTax for tax or related to our will writing? Either people are using or you suggest to use?
I cannot hear it.
He's
Can
asking
you
for a one
unmute
shoe that
everybody? Can
fits
you
all.
everybody unmute if you are not
Can you
speaking?
hear me now? Hey,
Please
Raju,
mute
can you
your
mute
phone.
everyone?
Mute your
Can you
phone.
mute everyone?
Those are not speaking.
Raja Bhandari ji, the question is there any site or any special package like for text you have TurboTax to create your will online? I remember you saying like it's not like a
He
one shoe
already
fit
said
all
it.
strategy, but he wants to probably hear it from you again.
Now, we see, a doctor will never say cut yourself. Doctor will never say that go to and take medicine the way you want to go over there. Even the pharmacy won't give you the prescription without prescription. So I don't want to say bad thing about anybody, but at the same time, remember one thing, very simple. I would say indirectly, if you work so hard to make money, all your assets, and this is a legal documents, please make your own judgment, because net is not the answer of everything. Because when we talk to client, they sit down with us, we talk to them so many things, we ask them so many questions, we find out that what kind of family it is, what their assets are, what their needs are. We draft the document for that particular individual when we do the case. So please, my humble request, again, you're the boss of your own destiny. You can do whatever you want or feel, but we don't get into this.
Thank
you.
you very much, Bhandari.
I have a question, Raja साहब. जी, आप क्या ट्रस्ट की मेंटेनेंस के भी हर ईयर चार्ज करते हैं? और एक क्वेश्चन उससे एसोसिएटेड है कि जब हम ट्रस्ट बनाते हैं तो एक मेरी फ्रेंड है, उनके हस्बैंड की डेथ हो गई, तो कार जो थी वो ट्रस्ट में थी, तो कारों को ट्रस्ट में डालना चाहिए या नहीं डालना चाहिए? कार को उनके नाम करने में अटॉर्नी ने $800 से $900 ले लिए. प्लीज शो द लाइट. आई एम डूइंग मॉम.
Well, again, I don't know how they transfer the car to the trust. That is strange to me. They
did in funding. They put the title of the car.
I know there is a document in our estate planning is called a assignment of personal property to the trust. Okay, but that doesn't mean that you transfer that car. It means that if something happened to husband, he owns the car, you can take that document to MVA and transfer the car to yourself. That is what see, this is what it's called. I don't know how they created that trust, who did it for them. This this is how these nitty-gritty things, that's the one hurt you later on when you do it yourself, and you do it from a person who might not understand the needs of you and or lack of experience. It depends. I'm not criticizing anybody, but you have to make proper decision that who's doing your.
So as it comes,
was done by
Bhandari, just one quick question. Can we have the trust attached onto the bank account? Nana is asking.
Sure, why not? You can, but we always recommend that you should open a bank account in the name of trust.
And the already open bank accounts can be transferred to the trust.
Some bank can do it. Some bank has to open the new accounts.
Okay.
So it's not a big deal. Let's say they know that. Remember one thing: when you create a revocable trust, there's no implication on your tax return. It's the same. There's no change in your status. It's the same. There's nothing that you have to change it or worry about it. Only thing you have to do, create a proper document and fund the document and maintain that document. Let's say that maintain means in future, if you buy something, make sure that it's in the trust. We always walk through the client properly. And then we always recommend open the trust. When you open a trust in the name of, when you open a bank account in the name of trust, they're going to use your social. That's all, same. Nothing is going to be different than individual.
Are there any special documents which are required to get a trust formed, Bhandari ji?
Special documents?
Like what documents are needed for will and trust? As my understanding from your presentation is, will is something that you write and get it notarized with witnesses. And I believe trust has a different procedure to be created.
No, I mean, trust will have same witnesses, same notarization. It is a large document. Like, for example, whatever my office creates, a complete package for one spouse is around 145 pages. So there will be two sets of documents, one for husband, one for wife. So we are talking about large document, and we are talking about in estate planning 8 to 9 documents, separate documents. So it is very hard for me to explain over the air, but once clients sit down with us,
definitely. This is such a critical subject that everybody, like I'm getting question after question. This is such a critical subject that one needs to sit down with an expert as you and discuss on the details. Everything is different for everybody.
Bhandari ji,
Anjuji, this is not anything that you should be scared of. Oh my God, what kind of document is that? Oh my God, what is going to, nothing.
Okay, Bhandari ji, do you have to file tax return for each trust?
I
drop the idea,
we're talking same time.
Dr. Gupta.
Okay, yeah, this is Ghanshyam Gupta. Do you have to file tax return for each trust every year?
Not individually, the way you're doing.
That means you have to file tax return for trust every.
No. Trust has nothing to do with the taxes.
Point.
How do you file your taxes, sir?
Because trust has all the items you put it in, you funded it, so it has some kind of income in it.
It is dealt with your social.
As I get it, Bhandari ji, your trust is your suitcase that is opened after you're gone, or like while you're working, you can put things into it, but carry on with your business just like that.
Absolutely. You can call it box, you can call it suitcase, you can call it paper person, you can call it company. Tax has no implications. Tax has no implication in this matter. Please try to understand. You will be doing the same thing you're doing today and tomorrow. You have a trust or not? Nothing.
So your tax bracket does not get affected with this?
No, sir. No.
Okay. Thank you.
Yes, I have a question. This is Sopal Dhanawar. This is a very...
Sasika.
Sasika, sir. Thank you so much. This is a very valuable information, a very educational
I want to add one thing. Mr. Singh did stories on this issue 2 to 3 times already for the last, I think, 10 years. And thank you so much for that, Mr. Singh.
Not an issue. And I'm so excited while Anjulji brought questions and lots of questions, and it refreshed my memory. And I'm going to request, I already sent request to Kripaji, but maybe he didn't check my message. I was just trying to record the questions as much as I can. And then I was thinking if I can air this story, because this is the way the questions came. It will be very valuable for especially our community. They are not computer friendly. And Pandariji, I am 100% with you, and I will stop by to your office one day, and we're gonna record one more story, not maybe this week
Sure.
in Punjabi.
Definitely.
Ganwa Sahab. So,
And Shashiji, can you send me some part of this 5 or 10 minutes? I will try
Ganwa
to.
Sahab.
Yes, sir.
Hello.
Yes.
Ganwa Sahab, the recording is being done by Bhandariji itself. He requested that can I do the recording, and we allowed him to do the recording. So he is going to send the recording to every one of us.
Yes, my office is recording right now. Yes.
Very good. Very good. I will request Pandariji and.
Sure, definitely.
Thank you so much.
Bhandariji, when you fund your trust, especially your properties, does it cost anything? Are there a lot of taxes to transfer the property in the trust or something? Your county or somebody, do they charge you?
Very, very good question. There is a small associated fee. There are several people involved. When we prepare the deed, then it goes to 1 or 2 places to record it, and then abstractor is involved. It doesn't cost more than, each county is different, probably between $300 to $500 for one property, because that is the cost associated with it. And when it comes to the taxes, taxes are exempt by the counties when it comes to the trust.
Okay.
As long as it's going from you to your own trust.
So even if the property is held jointly between me and my wife, and we are making 2 trusts essentially, still is considered the same transaction, right?
Yeah.
Okay.
Bhandariji, following on a question, as I understand, is once you have created a trust, if you acquire new property, you can always add that property to the trust?
Not only you should, you must, because otherwise, as I mentioned before, let's say that today, Anjuji, like you own 5 properties today. And then we created a trust for you. We put all the 5 properties in the trust. So funding is done. Tomorrow you decided to buy a new property and you buy only on your name. Now that is not part of the trust. So your loved one end up in a probation because they have to probate that particular part of that property, not other 5, because 5s are already associated with you. 5 already put it in the box and suitcase.
It is like Raja Karn ka Koch. Everything has to be behind it.
Yes,
to
right.
shield us
Because
from
that is
the probate.
because you don't want to go to court. Our whole idea of trust and estate planning is stay out of the court, distribute all your assets, money to your loved one without going to the court. Because when you are in the court, all expenses going to remain the same. If it is 5 property or 1 property, it's going to, anybody can challenge. Then when they challenge one property, they're going to ask your what you call assets. Then you're going to bring all the assets. You don't want that.
Yes.
So it is in fact, that will be more dangerous than to begin with.
Definitely.
Because when they ask your assets, they're going to ask your assets for the trust too. Maybe you end up disclosing all that, whatever.
And at this point, we would like to say, if someone has any personal questions or discussions, you can directly send an email to Raja Bhandariji.
Yeah, this is Mr. Satish Mitra again.
our session is getting towards an end, and I would request
Bandariji, one
Gopinath
last question.
Durgai Naidu.
Yes, I have one question.
What if you sell one of
Bandariji.
the properties?
You say, please, one by one.
Yeah. What if some of your loved one, like your brother or sister, live in India? How can you include them as part of your trust?
Sure, why not? You can include anybody you want anywhere in the world.
Okay.
Only thing is that when they will receive something from you, they have to shell some money to Uncle Sam.
Okay. Thank you.
Then if I'm an Indian citizen and my brother is here, and let's say that I got his house, and then that particular money I have to disclose to the IRS and then pay proper taxes as a foreigner.
Okay.
Then, yes.
Bandariji, what if one property is sold from the trust? If there are 3 properties in the trust and one is sold, then do we have to take it out?
Well, when you will sell it, it's already out.
Do you have to change the trust?
No. See, trust is a body. We don't change that particular big, large document. Whenever there is number one, we do not have to mention in the trust that you own 3 properties. There are different ways we can manage that. You don't have to keep changing. Follow my point?
Okay.
Raja Sahab.
Yeah, but
sorry.
Say, for example, I have 2 properties. I already put it in the trust, out of which I sold one. Do I have to do anything? If I buy one, I have to add it. But what if
again,
I sell one?
Without looking at your trust, I cannot make a comment. But again, whoever put it in the trust and did it that way, that is a more expensive work in future for you. My goal is to make a document for you so you don't have to keep spending money. I am trying to, I don't know which way I should express myself from my heart. I am trying to do certain things for you so that way I can get du'ain. That is what my wealth is.
Yeah, thank you very much. And if you're planning to sell a property from a trust, is it how easy or difficult it is in comparison to a property just on your own name?
Remember one thing, there is no change. Only thing, like for example, I want to discuss with you all, I have a title company separately other than my law office. So in that title company, which is we call Saxon Settlements, that's owned by me. We do a lot of closing, and I don't want to take advantage, but at the same time, trying to tell you, I was one of the first attorney to open the title company in 1987, community-wise. So we are working since then in that title company. We do closings. We do closing for houses, refinances. We also do closing for the businesses. Now, when you come, let's say that you have a house in the trust and you are trying to sell it, but we will ask you, show me your trust. I want to see you have powers. So when I see that you have powers, no issue. Then you can sell easily and it goes to your account. Just like you individually sell it.
Thank you very much. And I don't see any more questions. I would request Gopi Durgai Naidu to formally thank you for your presentation. Everybody has already expressed great thanks to you and gratitude by Dr. Harswarup Singh ji. It was very informative. Now I would have our past president and current vice chairman Gopi Durgai Naidu to thank you, give a vote of thanks.
Thank you, Anjuji.
Yeah, you're welcome. Thank you, Ji.
Thank you, Sashiji. Can you, Anjuji, can you hear me?
Yes, we can hear you.
Yes.
Okay, thank you. Wow, what an interesting program.
Okay, go ahead now.
I hope you all will agree that we certainly had a very insightful
and educational and useful advice from our own Raja Bandari Esquire, who has been very much involved with the community in the metro region, Washington, D.C. metro region for several years. And he's also conducting a educational TV programs on similar line in our own Nilimaji's global television sometime on weekly basis. Thank you, Raja Bandari Sahab, for your insightful advices. And we wish you all the best in giving us continued advices going forward as well.
Hello.
And I thank. Can you please mute your line?
आशा जी प्लीज म्यूट करिए फोन
फर्म देख के क्योंकि
राजीव, can you mute everybody?
आपकी गलती नहीं होती लेकिन उन्हें देखना पड़ता है
आशा जी अपना फोन म्यूट करिए
गाजर और
she don't listen
papaya and
so
everybody please mute
your phone. Rajiv, can you mute everybody
मत लाइएगा
except
छांट के एप्पल लाइएगा 5-6 बड़े थैंक यू
Okay, I thank our senior advisor, Ambassador Dr. Ashraf Singh, for his excellent welcome remark, and his continued advice to our organization. I like to thank our Vice President, Mukunda Kashe, who is also the event coordinator of this event. He brought such an excellent idea to the leadership team to have a very meaningful event or information session to the community. And thank you, Mukunji. I also thank our smart moderator who have moderated this event Q&A session. Thank you, Dr. Anjuprit. I also like to thank our leadership team, which include the past president, Kripa Singh, and our president, the sweet mom, Naina Desai. Also, the dynamic executive vice president, Sashi Agarwal, and Asha Chand, and many other vice president. And a special thanks always goes to our own chairman, Sunil Singh, who actually, find the potential opportunities that actually benefit our community at large. And he presents the opportunity to the leadership in our organization and also the, businesses and others in the community to benefit. It's a win-win situation for the business as well as the community and the members of the organization and our community, which continue to gain knowledge through these sessions like this. And we at NCAIA, we have conducted sessions like this in the past, and this is one of the event in the series of things like that. So we have done the COVID-19 educational session, and we have done again the vaccination program, and NCAA has been actively participated in the task force with the embassy in helping the community handling the COVID pandemic situation. And it is continuing to present such an excellent events under the leadership of our chairman, Sunil Singh, and our other leadership teams in the board. I like to thank our other senior advisor, Dr. Banik, and also our advisor, Shukpal Dhanova, and my fellow vice chairman, Dr. Yogendra Gupta. And it's very hard to list every individual's name, and please apologize. I offer my apology if I missed your name. And I close by thanking all the participants who made this event such a wonderful event, very engaging and interactive, which has been a key vitamin for Raja Bandari Sahab to continue to present his insight to our participants. Thank you all again.
Thank you so much.
Thank you very much.
Thank you, Raja sir.
Thank you very much.
Thank you so much.
Thank
Thanks
you.
for the wonderful
From
session.
my side, I thank you each and every one of you and the whole community at large. And Dr. Singh, as you mentioned, that very close friend of mine. And thank you so much, Dr. Singh, for giving the opportunity, as well as the whole organization for that matter. And I hope and I pray that I serve whatever I was supposed to in this particular matter. And if there is any question that you would like to, of course, you can reach me anytime. My site is rajabhandari.com. My phone number 703-941-1850. Or you can Google me. You can find me over there. So any question that you were not able to ask, or if there is any help that I can do, I will do my best and then to serve my community. Thank you again so much from my heart.
Thank you. And I missed one name